Hi, this is Brett Sankis with Sankis Law. Today we're talking about indemnification clauses. Indemnification is an agreement among parties to a contract for one of them to be responsible if a certain type of thing happens. So for example, very good example is I hire you to be my salesperson. You are out there selling my products. You are making a small commission for doing that, and you ask me in the contract we sign to indemnify you if a customer named you in a lawsuit. And I may say, that's fine. You're just getting a little commission in my product. If they're upset, they might name everyone and, our grandparents in that lawsuit. And so you want some protection from that. That's a reasonable ask. And I may say, okay, unless you misstate something, common carve-outs, or unless you're grossly negligent, stuff like that. But yes, I'll take that responsibility on. And absent that indemnification clause, if that third party sued you, you may not have a right to come after me. You may. It's called, basically, maybe it's a cross claim. I mix that stuff up. But basically, you could make a claim against me if I'm primarily liable. But the indemnification clause makes it more clear. It also brings in a concept called defense. So the general language you'll see is, Brett agrees to indemnify, defend, and hold harmless Sarah if A, B, or C happens. And so beyond just me being responsible for the damages you suffer, which you may be entitled to just based on basic contract law or general theories of negligence, this says, no, you have to actually pay for the lawyer to defend me against this third party. And you will hold me harmless. You won't come after me for this issue. So it's a more fulsome, sort of clearer representation of a shifting of risk than relying on just breach of contract or negligence. And it's particularly helpful when we're saying things in a contract other than what would already be the case. So sometimes I'll read a contract that says, Party A agrees to indemnify, defend, and hold harmless Party B for any breach of this contract by Party A. Well, that's just what the deal is anyway, actually. That's just contract law. I guess it could have a little bit of unique meaning vis-a-vis a third party. So in other words, if a claim comes in from a third party, the fact that I have to pick up that defense, if I'm the one that gave you that breached the contract, may look different than what it would look like under general contract law. But if what happens is I breach the contract, you have some direct damages from that, well, you had a claim under breach of contract, just general contract law to begin with. So that indemnity doesn't serve a heck of a lot of purpose. It does serve a lot more purpose if we say something like I said in the original example, which is you're my salesperson, you're out there, and if a customer sues you, absent you being grossly negligent or intentional misconduct, like purposely telling that customer something false, I will be entirely responsible for this. When I was working for an oil field services company, you might have heard me talk about that back in the day. We had something called knock for knock, and what that would say is, so we had these massive boats that would be taking people offshore and helping. We'd drop remote operated vehicles down under the ocean bed and work on offshore oil rigs and all that. It was really kind of complex and dangerous stuff. And so we would have indemnifications that said, hey, it doesn't matter who's wrong, who does something wrong, who's negligent, whatever, you are going to indemnify me for anything that happens to your people and your property, and I will indemnify you for anything that happens to my people and property. So it's called knock for knock. I'll take my knocks, you take your knocks. And that's very different than what would be typically the case under a general negligence theory in the world. It would be if you do something wrong, you've got to pay my damages. This says it doesn't matter whether you did something wrong, you didn't do something wrong. If something happens to my people and my property, I'll be responsible for it. And the theory in that world is that, this is risky stuff and everyone is doing their best because it's just really very risky stuff, and people can, die with some of these types of services that are being provided. So companies, they would have to be the worst type of person in the world not to try and be minimizing that stuff. There's a lot of money spent on safety and health. So I think you trust that your counterparty, your contracting party, is doing their best to keep damages to their stuff and injury to the people to a minimum. So the idea is, let's just take that for what it is, and let's say that if something goes wrong, We want to just be very open about what happened. We don't want to start hiding behind lawyers because we're worried about lawsuits. We would just want to say, look, where did this go wrong? How can we do better? So that's very, very common in that context. And there, the indemnity makes a whole lot of sense because it really does alter what the world would be otherwise. So if you have questions about indemnification clauses, you're looking at something you don't understand or just doesn't make a lot of sense to you, reach out. If you have comments, certainly drop it. If you've enjoyed this video, subscribe. And I appreciate you spending time with me today.